Thanks very much. Thank you. Let's go ahead and get started. We're going to do some property first, and then we will do wills and trusts second. And for the wills and trusts, we're going to do both multiple choice and essay. As I said, we'll start with the property. Before I jump into the property, a couple of things on essays. I'm caught up through Sunday. But I know a number of you have sent me essays on Monday and Tuesday. If for any reason you sent me something through Sunday and you haven't gotten a response, then let me know. Occasionally I have had a few that have slipped through the crack. I'm trying to do them all in order as they come. So that's number one. Number two, remember that we do not have one of these classes next week. It's a short week because of the holiday, number one, but also it's scheduling in large part to accommodate your commercial course classes. We will meet again on the 8th of July, which is a Tuesday, again to accommodate the PMBR, 3-day PMBR classes at the end of that week. And that session on the 8th will be business entities. Any questions, any comments, anything anybody wants to get off your chest besides I hate the exam? Okay, so we're going to begin our discussion of property. And did we, you know what, let me just have you pass this around. I can't walk it around myself today. I picked out a question today on purpose, one that is not just straight property. Because some weeks ago when I did the session, the first session on the Florida subjects, I said, yeah, they probably aren't going to give you a straight up property question. I still think that's true. They had a big juicy property question with easements and all sorts of traditional property stuff last time. So I really don't think you'll see something like that this time. That's not to say that they won't throw property in somewhere. Remember, they can test up to 3 subjects per question, and they've been doing a lot of that. This question is a nice combination of contracts and property. Many of you have written practice essays dealing with that type of subject matter. They love to do that. So be aware that property and contracts go hand in hand. There is also something else buried in this question. And I'll be curious to see how many, a different topic, how many of you can find it. And I will admit that when I first started using this question, I didn't see it. And a student pointed it out to me. So use your keen senses of observation. Take a few minutes, read the question, pick out the issues, and I'm telling you there is something besides contracts and property stuck in there. I'm sorry, find the one that looks like that on the front. It's on the very back. It's a short fact pattern. Just read it and spot some issues. Okay, take a minute or so and finish up, and we'll see what we've got. Okay, so let's take a look at this question. I like it for a lot of reasons. There are certain things about it I don't like, but it's one of the reasons why I do use it from time to time. It's a landlord-tenant question. If you don't like property, if you think you can't get property, landlord-tenant is one of those things in property you can get. So don't completely write property off because you may get a question like this that you can actually write something about. So that's number one. Number two, I want to point out, not raised by this question because it's residential real property. If you've looked at your Florida distinctions, there are rules for residential and non-residential leases. And they do like to test the non-residential, so make sure you know the differences between the two. Again, we're just going to look at the residential here, but a frequent flyer on the Florida exam is a non-residential lease. And then, of course, as I mentioned, that combination of contracts and property, unnatural, with a little bit of something else thrown in. What I don't like is it's kind of vague in places. It's open-ended in places, which makes the answer a little bit harder to write. But it's one of the reasons why I like to do it, because I've seen that a number of you have struggled some with structure. So I'm going to suggest how you can go about coming up with a good structure when you have a relatively vague question. So if we start up at the top, we see that Lars and Loretto own as tenants by the entirety that single-family residence. Well, remember, every fact matters. And by the time you get to the end of the answer, you should know why it matters that Lars and Loretta own as tenants by the entirety. Marla, because?
They're married and they both have to...
Okay. Loretta didn't sign. And so we may have an issue because we're missing her signature. They're tenants by the entirety. They each have to sign. And they are seeking your advice. We've got the Lakers, who are the tenants. I'm sorry, they're suing the Thompsons, the tenants. It tells you that you've got a notice of lis pendens, which really doesn't affect the outcome of the case, but you probably want a sentence. Anybody know what a lis pendens is? Just says there's litigation pending. That's all you got to say there. It really doesn't affect the outcome, but if they give you something like that, then you show that you know what it means. So the Thompsons are seeking specific performance of an agreement for purchase and sale of real property. So there's your mix of contracts and property, a very common one on the exam. And here's the agreement. It's handwritten. Do we care if it's handwritten? No, it's in writing. And of course, if it's an agreement for the purchase and sale of land, we know we need a writing. Statute of frauds will require it. It's in the kitchen of the subject house. That's actually an important fact there. Why is that an important fact? Read those facts. Ask yourself, what's that fact doing there? Look at the writing.
Just thinking because of, like, you have a duty to disclose, and then they're already in there. Something.
Well, no, it could be, but that's not it here. It could be, but look at the agreement. Well, not just identity of the parties, although that's significant. You've got to describe the subject matter, right? It's a contract for the sale of land. Contract for the sale of land has 3 essential terms, right? You do, as Jaquetta correctly said, Jaquetta, correct. See, I can't even say it right. Jaquetta correctly said. Sorry. Jaquetta correctly said you need to identify the parties. You must describe the subject matter with sufficient detail, which I'll talk about in a moment in this context. And you have to stipulate the price if it's agreed on. And if you look at that writing, does it tell you what the subject matter is? No. But they're sitting in the kitchen of the subject house. There's a difference between a contract for the sale of land and a deed when it comes to the detail that's required in description. For a contract for the sale of land, you just need enough detail so that the two parties to the contract know what's being bought and sold. They're sitting in the kitchen and they say rent, an option to purchase, and whatever. It seems like they understand what's being bought and sold. Different from the amount of detail and description that's required for a deed that is going to be recorded, because then you need enough detail to let the subsequent bona fide purchaser for value without notice out there know what was being transferred. So we have a very definite issue here in terms of subject matter. It should be enough because it's the only house they have and they're sitting in it when they execute the contract. So I keep saying, let those facts talk to you. Don't just stare at them. Every fact is there for a reason. Rent for 1 year, $600 per month. We know we have a lease. And then it also says option fee paid monthly, $160 per month. So we know we've got an option, and of course an option, this contract, by the way, of course, is going to be governed by common law, because it's land, and an option contract in common law has to be supported by consideration. Now, I will tell you there's one thing in the fact pattern, several things, but one I'm going to point out, I don't have a good explanation for. Notice that the rent is $600, option is $160, total month payment $760, received $720. Not sure why they did that. And usually I can figure out why. I honestly can't tell you why they don't match. But even if they don't match, there's still enough to support the option here. There's enough consideration. So I might mention it, but I can't see it affecting the outcome of the case. Do you all see the difference in the math there? All right. Thompsons may exercise option at any time during the 12-month period. If it's a valid option, I'm sorry, question?
If they did that, does that mean then even if like the wife had signed it, they had never paid the option amount with the payment?
Well, remember, the option is $160, the rent is $600, and they paid $720 out of the $600. A difference in $40, I don't think is going to make a difference.
So the first month's option, therefore, if they didn't pay it, then
Maybe.
from the beginning,
Maybe. That's one of the vague things about this question, because and it's a good point that you raised. The problem is that they don't give you enough information to follow it through. It's one of the things I don't like about this question, because I don't know, did they not pay all of the rent? Did they not pay all of the option? I don't know. And so I wouldn't go too far down that rabbit hole, because you don't have enough facts to work with. Note it, but beyond that, I don't think you want to get too tied up in it. They have to exercise within the 12-month period. And cross over to contracts, we know that if you're going to accept an option, the acceptance is good when? On receipt, not on dispatch, right? Very important. Difference, a big difference between Article 2 and the common law. In general, between options and non-option contracts, because for a non-option contract, generally speaking, acceptance is good on dispatch. Here, however, if it's an option contract, or quite frankly, a firm offer under Article 2, acceptance good on receipt. If Thompson's purchase, the entire $160 option fee plus $300 of the rent will be credited against option price, sale price $50,000. That sale price $50,000 comes back up, right? Because there's going to be an attempt to modify the sales price. Thompsons pay all closing costs when, if they exercise option to buy. Well, you pay the closing costs when you close, right? And so really about all you need to say there is that those closing costs won't be due unless and until they close. Fair rental value of the property is $450. Do we care that the rent is more than the fair rental value? Not really. Parties are free to agree on the rental price. Lars, Todd, and Tina signed. Well, we know Loretta is missing. But there's a little twist there, which we'll come back to. Thompson's moved in, which becomes significant. Why does it become significant? They moved into the house? Part performance, thank you, yes. Because if for any reason that writing is not sufficient, because for one, the description may be for one, number two, Loretta didn't sign, maybe number three, that issue with the consideration. If they move in, that's one of the things that's required for the part performance exception to the statute of frauds. You need payment plus. You need to move in, you need to make improvements, do something that shows that what you're doing when you're on the premises is unequivocally tied to the contract for sale. You're not just acting as a lessee. So you make improvements that a purchaser would make, not improvements, a little bit of paint, for example, that a lessee would make. So they move in, significant. Now, despite the protests of Lars, lessor, they're frequently late with their payment, the Thompsons. Now, of course, late payment is a breach of the lease, right? But waiver, absolutely. Okay? So they give you all the dates where they're late, and then, yeah, right, the payment's due on the first day.
It doesn't say.
It doesn't, oh, it doesn't say, right?
It's just the years.
Correct.
So basically, you have to pay the year's amount. It doesn't say, I mean, this is month to month.
Yeah, well, it's month to month. It says they pay each month, and you're going to presume, that's a good point, though. You're going to presume it's due on the first unless they state otherwise. Yeah. Now, now Todd tells Lars, I'm sorry, Jaquetta, you had a question?
Yes, it was about the waiver. So even though you're protesting about accepting the late payments, if you accept it at all, it's considered.
Right. The question that's raised here is if you later on say, ooh, you paid late, but you repeatedly accepted the late payments, that can constitute a waiver. Absolutely. Now, we're going to have some non-payment here as well that wasn't waived, and so there's a breach there. But what they're trying to get you to do is see the difference in the kinds of breaches that a tenant can commit, and we're going to look at those in more detail. Todd now says he wants to exercise the option. Does he have to exercise in writing, by the way? Doesn't say, does it?
So you could accept in whatever manner.
He can accept in any reasonable manner. He says first he's accepting, and then later on he submits a written acceptance. But think about your offeror as the master of the offer. Did Lars say you must accept in writing? No, he didn't. And so the oral acceptance should be good here. Now Lars is annoyed with them for their late payments, and he realizes the property's worth more, so he says, nope, nothing, I'm not going to go through with the sale unless you pay $55,000. A fairly frequent issue, and I've seen some of you struggling with what should be a simple issue. Lars is trying to do what to the contract? Trying to modify it. And of course, it's common law, so you need new consideration. Modification has to be in good faith, but what else? And this is the point that people keep missing, which should be so simple. Modification, can one party unilaterally modify a contract? No, you have to have agreement to the modification. And it surprises me, it's such a simple thing. It surprises me how many people have been missing that in essays. They've got, you know, Lars cannot unilaterally impose that modification. The Thompsons have to agree. So Todd sends a letter now demanding conveyance. There's his written exercise, if it's even required, which it probably isn't. And the Lakers respond saying they would convey for $55,000. Again, unilateral, not good enough.
Would you bring up the fact that could be like a repudiation? The fact that he said, I'm not going to sell this to you unless they consider it?
It could be. And that's part of the issue. If it's not a successful modification, has Lars repudiated the contract? Absolutely. Absolutely. So Lars is angry. He wants to evict the Thompsons. Here's a subtlety again that you might not be thinking about. The method used to remove the Thompsons from the premises. If they're tenants, what's the proper method? Summary eviction. If they are vendees, under an option to purchase, ejectment, the old common law ejectment, which is a longer, more complicated cause of action. Ah, yes. And they definitely were asking you to consider both here. So again, if they're lessees, summary eviction is appropriate. If they're vendees, then you need ejectment. So now we get to a very, very, oh, and of course, they throw in the obligatory changing the locks. You get a freebie. If you have a landlord-tenant question, they're going to give you that one freebie. We all know that you can't do what? You can't use self-help. So one sentence, though, okay? Don't get all carried away and have 5 paragraphs on self-help because you recognize something, right? One sentence, 2 sentences maybe, okay? Yeah, it's a feel-good thing. And you don't look the gift horse in the mouth. If they give it to you, write about it. So now, here comes a very vague call of the question, folks, and this is one of the harder parts of this question. Advise Lars regarding legal methods to force the Thompsons to vacate. Also advise them regarding likelihood of success, probable outcome of the suit, any potential liabilities, defenses available to the party, and damages, and what's the weather today, right? It's just tell me everything. I'm going to show you how I broke the question down, because it's a very broad call. I can't promise you that it's the approach that the grading outline took, but if I had written this question, it's how I would be looking for an answer. So, first thing I'm going to do is answer that first question, which is the methods available to remove them from the premises. I'm going to examine them as lessees first, and then I'm going to examine them as vendees when they exercised the option to purchase, because the rules are different. I would not try to deal with both of those situations together. You're going to get a really jumbled mess that's going to be very hard to read. So, grounds for removal if they're tenants. Well, we know there are several things that they didn't do right. They didn't get out at the end of the term, right? So that's one ground for removal. And if your tenant holds over, your tenant is a holdover tenant. Was this, and remember again that this, it says rent for 1 year, so it's a term of 1 year. It's not a periodic tenancy, and so they held over when they exceeded 1 year, which they did in this case. And the lease will be terminated. The lessor, of course, gets an option. The lessor can terminate the lease, or the lessor can choose to continue the lease now as a periodic tenancy. Clearly, in this case, the Lakers want the Thompsons out. So the lease is terminated, they're holdovers, and of course in Florida, if they're holdovers for the holdover period, if the Lakers choose to evict the Thompsons during the holdover period, the Lakers can get double rent, right? Which is the Florida rule. It's also probably the rule that you learned in your property class and in your multi-state materials. We'll see some places here where the Florida rule is different from multi-state. Make sure where there are Florida-specific rules that you state them. When you write an essay in torts, I see somebody was doing the Marina question here, which had Florida issues. This question will have some Florida issues. You're going to get points, a lot more points, if you know Florida law. So, one ground is, first of all, the holdover. Second ground, failure to pay rent. Non-payment of rent, of course, is a material breach of a lease. And here we're going to start to get into some Florida rules. Because the question is, first of all, was there a waiver? In terms of the late payments, yes. Non-payments, probably not. And what do you do if you have a tenant who has failed to pay rent? You've all seen it probably. You post the notice on the door, right? You're actually supposed to serve personally, but if they're not there, then you post it on the door. It's a 3-day notice. But there's a little twist there. Again, Florida rules. Does anybody know what that little twist is? 3 days? Ah, yeah, you have to. Hang on a second, let's go there. It's got to be Sundays, weekends, and holidays excluded. I don't know where I've got, there it is. Saturdays, Sundays, and legal holidays excluded. They posted the notice in this case when?
So what are you saying now, Friday?
Friday. They posted the notice Friday. And, so, I'm sorry, Saturday. And they told them to get out when? Tuesday. Enough time? Nope.
Wednesday.
Oh, yeah. So when you post a notice for non-payment of rent, and it's the thing you see on the door, Saturdays, Sundays, and holidays excluded. You have to give them 3 days, 3 business days. Look at the little things that they pack into the question. All those little things are getting you points that bloop. How many of you even thought about that when you read the question? Yeah, right? That's why I keep saying, pick those facts apart. If you glance at the fact pattern and start writing right away, and I won't ask how many of you are doing that, but I bet most of you are, right? You are going to miss so many points. And I keep saying it because it's true, and I'm not the only one who says it. Everybody across the state says the same thing. You're going to pass or fail Florida on the basis of your essays. That's what happens. It's not just a St. Thomas rule, it's a state rule. You've got to write 3 good essays to pass Florida. And you've got to read the fact pattern carefully because they pack so much into it. So they got to repost the notice here if they want to evict them for non-payment of rent. So if they're holdover tenants, of course, they can proceed immediately to summary eviction. Because a holdover tenant is just a what? Trespasser, right? So if they're trespassers, they can evict them right away. But if they are trying to evict them for non-payment of rent, they got to repost that notice before they can evict them. And they probably cannot evict them for late payment because they probably waived the late payment. So look what you've done here. You're talking about eviction if they're tenants, and you've got 3 different grounds, and you want to follow each ground through. Now we're starting to see some structure in a really fuzzy question. Self-help, not going to go through it again. Put it in there someplace. Put it in there someplace in your discussion of the lease, obviously, because it's relevant to the lease. Very easy. Now, let's look at the option to purchase to determine whether the Lakers can remove the Thompsons from the premises if they have exercised the option. We need to know first if the option was valid in the first place. So what do we need? We need the writing. We have a writing. Handwriting, that's fine. And that option, of course, needs to include the language of the option notice. It says option fees, Thompson may exercise. It's clear that an option is intended in this case. What else do we need? Consideration. I'm sorry, Yasmani?
What point in time do we go into what law applies and all that? 'Cause I'm
Oh,
getting
yeah,
contracts now.
it's a good question. Yasmani's question is, if we're getting into contracts issue here, should you have a sentence that tells you what law applies? Yeah, you should probably write at the beginning of this section, which I didn't do. But I would just add a couple of sentences saying, we've got an option to purchase, it's a contract, but this contract is governed by common law because it's land. So very short and to the point. Now, consideration, we talked about again. I don't think they intended it to be a big issue because it's certainly legitimate to ask whether they properly paid it, but the facts are so fuzzy that I don't think you can go too far down that particular avenue. Statute of frauds, though, big issue. We've got, first of all, parties, Lars and Todd and Tina, but it doesn't identify Loretta. Do we have a problem? She's sitting in the room, though. And remember, when we're talking about a contract for sale, we need less detail than we need in a deed. She's sitting in the room, which is going to become important in a moment. I'm sorry?
How do you know she's in the room?
Oh, I thought it said she was. Maybe not. I'm sorry. I don't have the facts right in front of me. I thought she was sitting in the room, but maybe she isn't. We'll come back to that issue in a moment because there is something, once again, that we haven't talked about yet that will help with the Loretta problem. Okay, time for the exercise of the option. It says 12 months, right? Remembering again, here's where you talk about the fact that the option has to be exercised within the option period. The exercise has to be received within the option period, which it clearly was in this case, both oral and in writing. Description of the property. That little lease document, once again, doesn't say anything about what the property is. Could be a fatal flaw. I don't really care what you resolve here as long as you identify the issue and talk about it. Probably they intended for you to say, yeah, it's missing, but they're sitting in the kitchen and they both knew what the subject matter was, which should be sufficient for a contract. But you're going to have a backup because you're going to say if the statute of frauds is not met for several reasons, part performance. So the question is designed to get you past that point. You just don't stop dead if you think that the description is missing. Now, signed by the party against whom it's to be enforced. Absolutely essential for the statute of frauds. And Lars signed, but Loretta didn't. Here's where they stepped out into another area of the law. Anybody see what is involved? Not con law. No, it's agency. Ooh, yeah, I know. The question is, was Lars, when he signed, acting as an agent for Loretta? He's her husband. Oh. Little bit of business associations mixed into this question. However, and here's where we get into Florida law. It's very clever, and like I say, I'll admit, first couple of times I did this question, I didn't see it, but the student who pointed it out is absolutely correct. Could Lars be signing as Loretta's agent? Yes, he could, because he's her husband, but there's a rule that you may remember from your BA class called the equal dignity rule. Let me tell you what it is. File it away, because it's a nice little rule to have. The equal dignity rule says that if the writing, or the contract, excuse me, is required to be in writing, then the agent who signs for the principal must have written authorization to sign. Equal dignity. Contract is required to be in writing. The agency agreement is required to be in writing. Equal dignity rule. But Florida has abolished the equal dignity rule. But look.
But not back then.
No, look at the question. They left off Loretta's signature. And then some people are thinking, oh yeah, equal dignity rule. Lars can't sign for her. But Florida law says yes, he can. Florida distinctions, folks. Somebody who wrote this essay knew that distinction. And maybe somebody, handful of people out there who wrote the question, knew the distinction. They got more points than anybody else. And that's the name of the game. Can you know all this stuff? No. But when we do Florida Con Law in a couple of weeks, the question I picked out, there is another rule in there that they've tested more than once that isn't in any of your outlines, and yet they keep testing it. And if you know the rule, you get more points. It's just how it works in Florida. Is it fair? But did anybody tell you this bar exam was going to be fair? I don't think so. So pay attention to the facts. Stare at them. Pick them apart. Don't be afraid to spend the time to pick them apart, because if you do, you're going to see things that they wanted you to see. If you blow by the facts, you're going to miss a lot of issues, particularly Florida-specific issues, and you're going to lose a lot of points. So, could you get a passing score on this exam without even thinking about the equal dignity rule? Absolutely. But would you get more if you knew it? Yeah. Now, so we go past that point, and the question is, was he authorized? I don't know, maybe. But if he wasn't, and if, here's where we get to the part that you do know, if Loretta didn't sign and the writing violates the statute of frauds because she didn't sign, maybe because it didn't have an adequate description of the property, and quite frankly, adequate description of the party since she wasn't named. Then we need to talk about part performance. Was this exception to the statute of frauds satisfied? And remember, part performance in this context, I have to tell you, tends to end up looking a lot like promissory estoppel. They're a little bit different, but even the restatement kind of jumbles the two together. Still, what they're looking for here is part performance, I think, because the Lakers, the Thompsons started to perform. They moved in. They were paying the option. Maybe a little late, but they're paying the option. So they're starting to perform. So what do we need? You have to take possession, possession plus. Take possession and do something that shows that you are possessing and making those payments in respect to a contract for the sale of land, not just for a lease. Absolutely essential for part performance. That's the hard part here. They did take possession. They were paying on the option. Did they do anything here? Did they remodel? Did they do anything else that indicated they were possessing as purchasers, not as lessees? Not really. So it's a tough one here, part performance. And if the part performance exception is not met in this case, then the option to purchase isn't valid. And if it isn't valid, we're back, of course, to lessees. So I don't think they cared which you concluded there. Yeah, it was satisfied. No, it wasn't. Question?
How could, it's a tendency that it's hard, like how could you convey something without your wife got sued?
Right.
Like, you're saying that's a statute of frauds issue?
The contract for sale. We haven't gotten to the conveyance yet, right? And you raise a really good point. Those of you who had me for property, you're going to say, well, there she goes again. And I keep saying it, and everybody still forgets about it. Keep your eye on the what? Phase of the land sale transaction. Some of you heard that more than you like. Actually, you guys didn't. You guys didn't have me second semester. No. You haven't heard it. Okay, keep your eyes on the phase of the land sale transaction. Contract for sale is here. The deed is over here. We have different requirements for the contract for sale. And things like, I've seen people getting this jumbled, marketable title, relevant to the contract for sale, completely irrelevant to the deed because it merges into the deed. What takes over afterwards? The covenants of title, and a lot of you have written about that. Don't mix them up. One set of rules for contract for sale. Here, was that contract valid? Did Loretta sign? Separate set of rules for the deed, which we never get to because they didn't get that far in this question. But a really good question, and just keep remembering, where am I in that land sale transaction? It's going to keep your focus, and it's going to keep you from writing about a lot of the wrong things. A very common error in a property question. You write about marketable title after they closed. You're not getting any points at all. Okay, so conclusion here, maybe part performance takes it outside the statute of frauds. Not completely convinced. It doesn't matter whether you say yes or no. It's how you get there. Now, let's talk about the modification. Once again, a fairly simple thing that I think it's so simple that we tend to forget because it's common law. We need, of course, new consideration. All modifications, whether under Article 2 or common law, have to be made in good faith, right? But in addition, you have to have agreement. And there was no agreement here. Lars said, I want $55,000. The Thompsons never said, okay, we'll pay it. So that modification is ineffective, even if you can find new consideration, which is kind of hard to find here, to be honest. So now the question is, if we have an acceptance, and that gets back to those issues that I just discussed, the oral acceptance should be effective here, if the option is valid, of course, because as the master of the offer, Lars did not indicate the method of acceptance. But just to be on the safe side, they threw in that written acceptance of the offer, which did, once again, occur within the time period. So if that option happens to be valid, then we've got a proper exercise of the option. Closing costs, I mentioned before, not much to say other than that you pay closing costs at closing, so they're not due yet, which is, I think, all they're looking for there. There's really not much to it. Now, removal of a vendee, if they are vendees or if they were there under the pretense of being vendees, but they didn't properly exercise the option because the option wasn't valid in the first place or something like that. They're definitely asking you to show the difference between summary eviction and ejectment. So just remember that. And if you think way back in your property class in your first couple of weeks of property, you talked about ejectment and then never thought about it again. Ejectment is the proper method for removing somebody who is not just a lessee. Could be a trespasser. You use ejectment to evict or to remove a trespasser. You can also use ejectment, for example, if you have a land sale transaction that involves an installment contract. So, and with an installment contract, the purchaser moves in and keeps making payments. But suppose your purchaser defaults, once again, ejectment is the proper tool. Now, we finally get to the point of the remedies. We want to look at specific performance. We want to look at what the purchase price is. And we also want to consider money damages. Starting with specific performance, of course, you need no adequate remedy at law, which is pretty simple when it comes to land, which I think most of you tend to get. If the Thompsons are suing for specific performance, they're trying to get land. They're trying to get this house. Each piece of land is considered to be unique, and because it's considered to be unique, specific performance is available. And of course, because specific performance is available for the purchaser, under that old theory of mutuality of remedy, which nobody likes anymore, but still there, if the buyer can get specific performance, so too can the seller. So just remember that, even though money's not unique. Mutuality of remedy, buyer gets it, so does seller. Other things to consider, by the way, about specific performance. Let me go back for a second. There are 4 elements technically, for specific performance. You usually don't need them in property law because you're talking about land and it's unique. But just remember, if you're in some other situation in which that remedy is specific performance, and that equity outline, by the way, that's in your book that nobody looks at, it's what it's there for, to help you out primarily with remedies. Other things too, but they do like to test remedies. So don't forget about that outline and remember to look at the different kinds of remedies. So, no adequate remedy at law. Second is ease of administration. You don't want the court to have to be involved in a complicated transaction that the court really isn't capable of handling. But here it's just a simple purchase and sale of a house, and so the ease of administration is certainly present. Third is definiteness and certainty of the agreement. Unless you think that there's a problem here with the description, it goes back to description, but getting past that problem, they talked about the terms of the purchase with enough specificity that it could be figured out. And again, it's a simple land sale transaction. And finally, that mutuality of remedy that I just mentioned. If one party can get the remedy of specific performance, then the other party is entitled. Now, what about money damages if the Thompsons breach? Well, if the Thompsons breach, and under the facts of this case, by the way, would the Lakers, and of course if the Thompsons breached, the Lakers aren't going to want to go through with the contract, right? So, can the Lakers get more than $50,000? No. They get $50,000 because that modification was not a valid modification. Why? Because the Thompsons didn't agree to the modification. And would we give money damages to the Thompsons? Well, you could. They probably don't want money damages, but you could. However, the question specifically states that they want specific performance. So I wouldn't spend too much time talking about the money damages that would be available to them. But it's going to be, Richard, I'm sorry.
So you wouldn't go into the option fee that they paid monthly? So I mean,
Oh, they paid that fee to keep the option open. So that's kind of money down the tubes. But you could talk about the difference between the contract price and the market price at the time. You could spend a little bit of time talking about basic measure of damages.
okay.
I wouldn't spend a lot. Jaquetta?
Yes, quickly. For some reason, I thought that if you did take out an option and if you did want to exercise the option, that one of your remedies could be that either if the option be counted towards the purchase price or you can get it back.
Well, that's,
Like
oh,
the down payment.
okay, well, restitution. Oh, I see what you're saying. Oh, I'm sorry. I think I Richard, you asked the question. I misunderstood. I'm sorry. I misunderstood your question, and I apologize. Can you get restitution? That's a different measure. Yes, you could get restitution.
Okay.
Yeah. And you know what? I don't have restitution there, and I probably should. But yes, restitution would be available. Now, one of the things that I see that people kind of confuse is your basic measure, expectation damages, and restitution, and reliance damages. There is a difference between reliance damages and restitutionary damages, and we see a lot of confusion. In this case, it would be restitutionary. You get restitution if you've conferred a benefit on another party. On another party to the contract. So in this case, the Thompsons would have conferred a benefit on the Lakers. They'd get restitution. It's not reliance. Reliance damages are available if you pay money to a third party. So if, for example, the Thompsons had, had bought some furniture in reliance on the contract or something like that, they're out of pocket to a third party. That's reliance. But here, the money that they paid to the Lakers is unjust enrichment, conferring a benefit on the Lakers. That's restitution. Yes, sir.
And where would that stop at? Would that stop at the $106 per month or the $300 towards
Yeah.
like the rent?
Well, think about it for a second. It's a good question. $300, yeah, the rent that they paid should they get restitution for the rent that they paid? No. Or the portion that represents rent? No, because they're not unjustly enriching the Lakers. They are paying, that represents rent for the premises that they got to use. So no, they should not get restitution for that.
Maybe I'm reading it wrong. It says the entire $106 option fee plus $300 of rent.
Will count toward, yes. Yeah, it says it will count toward the purchase price, which means if the Lakers ask for specific performance of the purchase price, they wouldn't get the full amount. And I probably should have added that there. But they won't get the full amount because you'll back out what was already paid. But if you're talking about restitution, they're not going to get restitution of what constitutes rent because they got value for that money. So yeah, in terms of the purchase price, the Lakers, whatever they get, it's going to be set at $50,000, but you do have to back out what was already paid toward it. Richard.
I know this is out there, but you know the answers to some of these essays
Yeah.
have been like throw me for a loop a little bit. But when we were discussing the rents and then the option and then it being accounted towards it, I almost thought installment contract for a second.
Yeah, not in this case. I understand what you're saying.
I would have gone down that road, but I just thought.
Yeah. An installment land sale contract is going to be set up a little more clearly. This is just an option to purchase. It's going to say that they are purchasing, right? And then again, it usually is combined with somebody moving in and paying the installments. But here it's phrased in terms of rent and phrased in terms of an option. So I would not go down the road of an option contract here. Excuse me, an installment contract here. Okay. Is there anything else? Okay. Yeah, go ahead.
Repudiation, you think it would have been like a long stretch here? Because the language kind of like.
Yeah, going back to the question of when they said we want $55,000, does that amount to anticipatory repudiation? I'm not going to say absolutely not, but probably not in this case, because they say, well, you know, we want to increase the purchase price. They didn't say we will not perform.
He did.
He did. Did he say that? I will not sell. Oh, yeah. You know what? It goes back to what we talked about when we did the contracts question. Remember the comment on the terms that we talked about. And the restatement says if all you're doing is commenting on the terms, then it's not a repudiation. Well, would I go there? Maybe. But I wouldn't spend a lot of time on it. Remember, this is a really open-ended question, and you could go down so many rabbit holes when it comes to this question, which is what I don't like about it.
Yeah, it's bad.
It would, if you followed everything through, it would be really hard to get it done in an hour. So you have to make some choices. Can I promise you that the choices that you make are the right ones? Nope. Yeah, not even, you know, but you do your best in determining. So, yeah, I didn't go down that road. I can't say that it's not one that you might consider. Sean, you had a hand.
Yeah, going all the way back to the beginning to the formation of the contracts. In the beginning, you were saying that the mutual agreement thing, like there was like a apparent authority for him to sign.
Maybe.
But given that there are
Yeah.
no facts that said that she was present during the formation of the contract or any of the negotiation or anything, is it possible to also make the argument that there was no valid contract and the Thompsons wouldn't be able to get the specific performance because you can't make the conveyance, but they still will be able to get the money back from the $160
Right.
a month payment?
Right, that's what we were just saying, yes.
But you were still going off of the fact that there was still a contract valid for the conveyance.
Oh, I used, I'm not sure I understand your question now.
It was my understanding that the slides that we've gone
Mm-hmm.
through have been on, like, with the assumption that Mrs. Laker was present while they were in the room signing, and she had given her husband the authority to sign for her.
Right. Once again, I understand what you're saying now. Once again, this question, you could go in 50 different directions, which is why it's a tough one to work, is why I always end up with conversations like this. I don't do this question very often because everybody wants to go in a different direction, and I can't tell you that the direction you're going in is wrong. What I am telling you is when you get a question like this, you have to make a certain set of assumptions because the facts are fuzzy, and you have to go with them. Can I promise you that my set of assumptions is the right one? No, I can't. But you can see what I've done. I've worked through as many of the issues as I could with my set of assumptions. Not to say that your set of assumptions is wrong, but you got to get through the issues. That's the key. And is this a tough one? Like I say, I don't do this question very often because we end up going 50 different directions. Whoever wrote this question didn't get a good rein in on it. And I have no clue what the grading outline actually looked at. All I can tell you is where I probably would have gone with it if I had written the question. But would you be wrong if you went down that other path? Not necessarily at all. And I can, you're going to have to make some choices, folks, and that's part of the lesson for today. It's why I use this question from time to time. Richard.
So I understood the road you went down, because I would have gone down that way because it mentioned specific performance.
Yep.
So you're going to need something valid
to get there. Exactly right. Because, the call of the question, and that's a good point, the call of the question says specific performance. If you don't go down that path, then you never get to specific performance, and you've missed part of the call of the question. So and that's another really important lesson, besides picking the facts apart. And by the way, you guys are doing a great job of picking the facts apart, which is really good. Look at the call of the question. It's a very fuzzy call of the question, but it did specifically say specific performance. So you know you have to get there.
Right,
By hook or...
You can't get to specific performance if you don't have a contract.
Yeah, I know. Yeah, right. But you have to. But then, if you follow your path, Sean, you have to say, "But if there was a contract, then," because they in the call of the question, they said address specific performance, right? Well, that's what the Thompsons wanted. So the fact tells you that they want specific performance. So you have to get there. And if you want to say there's no contract, but if there was, then you can take that route. End up addressing the things that they want you to address. Question?
In the more recent fact patterns that we've been going over for the past bar questions, they usually hone in on specific issues. Would you say that that's more the reason?
Yes, and it's a good question. The new style of essays, which Florida uses. Florida doesn't use the new style of questions for multiple choice, but Florida does use the new style of questions for essays. And the new style tends to have a really pointed call of the question, very directed and very clearly addressed. But, folks, you can't guarantee that you're going to get a new style question. You've got to be able to address a question like we just did. What did I tell you at the beginning? I said, this is a problematic question because it is so open-ended. And you've got to be able to handle questions that are open-ended, questions that aren't open-ended. When we get to the trust question in the second half of the class, you're going to see a question that's very pointed. It's got 4 parts. You answer the 4 parts. This question doesn't. You can't just say, oh my God, what do I do? Right? You've got to plot out your path and get to the end, to the things that you hope they wanted you to talk about. That's all you can do. Okay. Other questions about this question? Yes, ma'am, Jaquetta.
During the, I guess the option period, when we're saying, like the closing and all this happens, is it that the closing for the option has to happen, like everything has to happen within the option period?
No, not the close. Jaquetta's question is, do you have to close within the option period? No, you just have to exercise the option within the option period.
Exercising the option, just say, hey, I want to do it.
Exactly right.
Okay.
Exactly right. Okay, other questions? All right, let's bury this guy. Are there other questions, though? Yes, sir.
I'm just looking at it. It never says he paid for the option, like the option fee. It never says he paid it monthly. But it doesn't say he made the payments on it.
Well,
he paid rent.
Yeah.
But it doesn't say he was making the payments on the option. Then it says
Okay.
in November he asked
Right.
for that option. So.
Yeah, it's a good point. I have to make the assumption when it says he's paying rent, because they say the rent and they break it down into two parts, right? That it's including the option, but maybe it isn't. And that's, again, another rabbit hole you could go down.
Sorry, just,
Yeah, no. It's a,
this guy's an asshole.
and honestly, let me just say one last thing about this question and we'll put it to bed. Again, it's why I don't do it very often. It's a tough question to negotiate through, because you could say, well, wait a minute. It says rent, it doesn't say option. You could go down that path and you could say there was no consideration to keep the option open. If no consideration is paid to keep the option open, wow, that's a whole nother path. Can anybody tell me what path you have to go down then? You know that path. It's what everybody always wants to talk about. If a contract fails for adverse possession, right? Everybody wants to. No! Hang on a second. Test your minds, folks. Test your minds. If a contract fails for lack of consideration, what does every first-year contract student want to write about? Promissory estoppel. So that's your path, right? I don't know if it works, but that's your path. If, once again, listen very carefully, folks, and then I'll let you take a break. If the contract fails here, and it could for a number of reasons, you can't stop there and go home. You might like to, but you can't, because they asked you whether there is specific performance available. So you got to get to that point and say, well, no, the contract isn't enforceable, but maybe it is. Part performance, which we talked about here, or promissory estoppel if there's no consideration. It still then gets you to the question of, is specific performance available here? So you've got to take those trips, or those steps, if you will. Because if you stop short and you don't talk about specific performance, you know you're missing points. Question?
Sorry, one more quick question. It doesn't say anything about the October rent. We do assume they paid it on time?
The question is, doesn't say anything about October, and no, it doesn't. They didn't pay November, they didn't pay December. So then, you know, there's non-payment of rent, so it doesn't so much matter about October, is the answer there. Okay, let's put this question to bed. And when we come back, we're going to do some wills administration multiple choice questions, and then we'll do a trust essay. We're not going to do all of the questions. We can't do all of the questions. We still need to do some trust as well. So I'm going to tell you which ones to do, and then you've got the rest of them. There are answers that they're right here, I will hand out to you. So I'm going to ask you now to pull out the wills administration questions. It says Florida wills and trust questions, and you are going to do question number 1. Go ahead and start with question 1. Okay, anybody else want to ring in on this one? Let's see how we did. Whoop. Okay. Oh, we're getting a few more. Okay, I'm going to call it. Okay. Okay, good. Most of you knew the Florida rule. And when it comes to wills and trusts on the Florida bar exam, you want to know the Florida specific rules. So if you had me or you had Professor Butler for wills and trusts, you got the Florida specific rules. If you had Professor Ronner, she does more of UPC and Uniform Trust Code. You got to learn those Florida rules. Florida follows the rule of strict per stirpe distribution. So let's take a quick look at the picture. It's always a good idea to draw the family tree. So here's our family tree. Our decedent is Dan. Question?
Yeah. Do you know on the bar how much scrap paper there is? Because a lot of times I find myself trying to draw little areas and make things work.
Yeah, it's a good point. When you're doing the multiple choice in the afternoon, they're not going to give you anything other than the booklet, so you got to draw in the booklet. I don't know if you can even ask for scrap paper in the afternoon. It's a good question. In the morning, you have your blue books, but and so you can draw all over them. I guess you have to draw really small. Yeah. But it's important when you do these questions to make the drawings, because if you draw this one out, there's our decedent Dan. He's predeceased by all 3 kids. In Florida, we look for the root generation. What's the root generation? It's the first generation after the common ancestor. If we're talking about children, which we are here, lineal descent, then it's going to be the children. The first generation with people born into the generation who either survive the decedent or who leave lineal descendants. Well, none of those 3 survived our decedent, but they all left lineal descendants. And the question now becomes, how do we divide? Strict per stirpes in Florida, you divide at the root generation. We have 3 in the root generation. Rocky gets that 1/3. Gideon gets the 1/3. Of course, Dakota gets nothing because Gideon is still living. And McGill and Lil divide the 1/3, giving them 1/6 each. I saw a couple of people who tried to do per capita. We don't do per capita in Florida. Any questions? Okay, number 2. Anybody else on this question? Very good. Now, I say very good with an asterisk because I'm guessing you've seen a question that looks a lot like that, so you remember the question and you can pick the right answer. But let me give you a formula for those of you who don't freak out about math anyway, that you can use when the question's a little more complicated than this one. We're talking about inheritance by half-bloods. First of all, you've got to distinguish between collateral inheritance and lineal inheritance, because if it's lineal inheritance, there is no application of the half-blood rule. If in this question, let's go to the family tree so you can see what I'm talking about, if our decedent had been the mother, so if you look at the picture, if mother instead of Rita had been the decedent, and we're talking about those two kids inheriting from mother, they're half-bloods, but they take equally because it's lineal descent. When it's collateral descent, Rita is our decedent. Then it matters that Martha and Bonnie are related by the half-blood. Why are they related by the half-blood? They share a mother but not a father. Here's the formula that you use, and it works in every case. You take the number of persons that you have who are related by the half-blood. If the person is, and in respect to the decedent, of course, if they're related by the half-blood to the decedent, you give them 1. If they're related by full blood, you give them 2. So, in this case, Martha, related by the half-blood, we give Martha 1. Bonnie, related by the whole blood, we give her 2. We add them up. 1 plus 2 equals 3. Now, here's where it comes hard for those of you who don't like math. You take the 3, the total of the parts, and that becomes the denominator of the fraction, the bottom part of the fraction. And then you take the part that's been allocated to each person, and it becomes the numerator. We gave Martha 1. We put 1 over 3, she gets 1/3. We gave Bonnie 2. We put 2 over 3, she gets 2/3. So my advice is to kind of remember that formula, because while you get these easy questions in the practice materials, that's not necessarily what you're going to see on the exam. Use the formula, you get the question right every time. Any questions about it? Okay, number 4. We're skipping over 3. Number 4. Okay, anybody else on this question? Let's see how we did. Pretty good. You guys know something about wills and trusts. I'm glad, since I see some of my students out there. You're doing very well. What's the hard part of this question? Really just the reading comprehension. Those of you who picked A, B, or C, what did you miss? Incorrect. And we know in Florida that we recognize a lot of different ways of revoking a will. The one thing you cannot do in Florida is revoke a will in part by physical act. And so if Billy draws a line through a portion of the will, he's trying to revoke it in part, that revocation is ineffective. That provision stands and the whole will stands. If you draw a line through the whole will, you're fine. If you draw a line through your signature, you're fine for revocation by physical act. But you can't just revoke a portion. Any questions on that one? Again, I think those of you who missed it, it was just reading comprehension. Okay, number 6. Okay, coming up on 2 minutes. Are we missing any? There we go. Okay. Let's see what we did. You guys are doing really well. It's excellent. We're talking about anti-lapse here, of course. And we know, I hope, that we have 2 different anti-lapse statutes in Florida. So you need to know whether you're applying the wills anti-lapse statute, which you are in this case, or the trust anti-lapse statute. Big difference between the 2, of course. There's a relationship requirement under the wills anti-lapse statute. There is not under the trust anti-lapse statute. We have a devise in this case, an outright devise, and so the wills anti-lapse statute applies. And that's what you have, of course, in choice A, because if Beethoven is Jude's brother, you have that relationship, a descendant of the grandparents of the decedent. So the wills anti-lapse statute protects someone who has predeceased the testator if that person is a descendant of the grandparents of the testator, and if that person leaves lineal descendants, which we have in this question. Any questions? All right, moving forward, number 9. All right, let's see how we did on this one. Good, but not as good as before. We're talking about a pretermitted spouse, right? What makes a spouse pretermitted? If the spouse is married after the execution of the will. Same thing, of course, for a pretermitted child who's born after the execution of the will. And that's what C tells you here. And of course, the pretermitted spouse share is the intestate share, which could be a lot these days because Florida's intestate distribution statute has been changed. If you have a spouse and children who are all children of that marriage, guess what? The spouse now gets the whole thing. So that pretermitted spouse share can be a big deal under the current law. Any questions on pretermitted spouse? Okay, let's skip forward to number 14. Oh, question, I'm sorry. Yes.
Is there a rule of advancement to them or like
It's Oh, yeah, it's not, those are exceptions. There are 3 exceptions. So if the will states that it is specifically intended not to give anything to a pretermitted spouse, that's 1. Number 2, if there's a gift made in contemplation of the marriage in the will. And you raise a good question, Kevin, because if the parties subsequently get married, subsequently meaning after the execution of the will, there will be a presumption that the gift in the will was made in contemplation of marriage. So yeah, absolutely. And I'm sorry, the 3rd exception, and if you're stumped, by the way, when it comes to wills, if you're stumped and you know there have got to be some exceptions, they almost always come in 3s. And the 3rd exception is if the spouse waives the pretermitted share in a pre or a post-nup agreement. Any other questions? And please do, by all means, jump in with your questions. If not, then number 14. Anybody else on this one? Always remember, folks, check your light to make sure that the on light is on. Going once, going twice. Okay, let's see how we did on this one. Okay, good. 2 sets of rules here. One for personal representative when there is no will, intestate distribution, and another when there is a will. So here we're talking about intestate distribution. The preference goes, of course, first to the spouse. Second, it goes to the person selected by a majority in interest in the estate. And third would be the heir of nearest degree of kinship. And by the way, when we say majority in interest, it's not the number of heirs, it's the heir with the biggest share. Now, if you have a testate estate, it's still 3 in terms of preference. First preference, of course, is to the person who's named in the will. The second is the person selected by a majority in interest of the heirs under the will. And the third would be any devisee. These kind of picky rules, these are the things that we tend not to cover in your wills and trust class. So if you're a little vague on this particular area, you might want to go back and review. I think there's a good chance you will get wills administration questions. So, cover that area. Okay, moving forward, unless we have any questions on that. Number 17. Okay, anybody else? All right. So, and what did I just tell you? The answer is C. This is the area that we don't cover in our classes. It's boring, to be very honest. That's why we don't teach it. But they like to test it. So the probate process itself, go back and review it, because you guys were doing great until we hit this little bump here. And again, probably because you learned it well in class to begin with. You don't learn this stuff. So let's take a look at what's going on in this question. Can we ever reopen administration? Yes, we can, but very limited circumstances. So it's not A, because it says never be reopened. You cannot reopen administration once it's closed for a newly discovered will. That will's got to come in during the probate process or it doesn't come in, which means that B is wrong. C is correct, and it's logical. Because if new property shows up, you got to distribute it somehow. And so administration will be opened, because otherwise that property sits in limbo. So it's a very logical rule. And D is wrong because it's not at the court's discretion. It's got to be newly discovered property. Yes, sir.
So that's the only scenario it's
Yep.
reset?
Yep, once it's closed, which means that the final accounting has occurred and all of the assets have been distributed and the court orders the estate closed.
A little out there, but if
Mm-hmm.
you do find additional estate property, and then there's also maybe a new will, would you go by the old will still?
Yep.
Original?
Old will, the one that was admitted to probate, can't get the new one in. Yep.
And the old property could be redistributed? Like there was, like the old, yeah, you find new property, but the old property.
It's already out there.
But like, so will they
No.
get that in? No, they're
No.
just gonna.
Just administer just the newly discovered property, correct. Yep. Any other questions? Okay, we're going to do just a couple more, and then we'll leave the multiple choice behind. Number 21. '21. 21. Okay, coming up on 3 minutes. Anybody else on this question? All right. Now, before I, and good, okay. Before we talk about the substance here, there are a few things when it comes to a trust essay in Florida that they almost always test. One of them is the spendthrift trust. They love to throw it in, so make sure that you're able to recognize it and you know the rules. Basic rules, of course, a spendthrift provision which prevents voluntary or involuntary conveyance by a beneficiary is enforceable in Florida as long, of course, as it's not attached to the settlor's own interest. You can never protect your own interest from your creditors. With that in mind, the property, while it's in the trust, is immune from creditor claims with 3 exceptions. There you go, that rule of 3 again. What we have in D is the first of the exceptions, which you all recognized, which is a creditor, a judgment creditor, who has provided services for the protection of a beneficiary's interest in the trust. The second, a few of you picked B, but it's not quite right, and that's the way they'll test you. You've got to know the whole rule. It is true that the trust is subject to alimony and child support claims, but only as a last resort. You have to exhaust traditional methods of recovery first, meaning garnishment of wages, for example, before you can attack the spendthrift trust. Third category is hinted at in I don't have it there. I used to have it. Change the question. It has to do with the provision of necessities. Under old case law in Florida, a creditor who provided necessary items could attack the spendthrift trust. That particular common law or case law rule is not included in the new statute. It's got a third category that might take care of some medical claims, but not your ordinary medical claim. The third category deals with the claims of the state and U.S. government, aimed at taxes certainly, but also probably Medicaid, Medicare, that type of medical provision. If you are just a private individual who's provided necessities to the holder of a beneficial interest in a spendthrift trust, apparently you no longer have a means of attacking the trust. So just be aware of that, because they do like to test that particular fact.
Will we mention it in an essay so they could know that we know that part? Or?
If it's relevant, yeah. If it's relevant, you know, you have to be careful. You've learned all of these rules, and I know you want to show them everything that you've learned, but resist the desire to dump every single rule onto the page, because you're not going to get points for rules if they don't advance the argument. And they, you know, I hate to say that they don't care that you learned all this stuff, but they kind of don't. You have to answer the question. So use the rules that advance the argument, no more, no less. All right, one last question. You guys are doing really well, though. I'm very impressed. Number 23. Anybody else on this question? Okay, let's see how we did. Really good. Okay, now, a couple of words, but clearly you knew what you were looking for. They love to test trustee duties on the essay portion of the exam. You're not going to usually see it in the multiple choice. I throw a few multiple choice in just to give you something to work with. But that's one of their favorite topics. So if your professor didn't get so far into trustee duties, because you tend to run out of time at the end of the semester, make sure you review trustee duties, because if you get a trust essay, you're going to have some kind of trustee duty. So there's no problem, because a trustee, as opposed to a personal representative needs a court order or authorization in the will to sell real property. But for a trustee, you don't need a court order, generally speaking, to sell property, especially since it's a sale for fair market value here, unless the trust document requires otherwise. B, you can receive a reasonable fee for administering the trust. Trustees wouldn't serve if they didn't get paid. C, we'll come back to, of course, it's the right answer. D, it's a change from the common law. Common law did not permit delegation of duties, but modern law and certainly Florida law permits delegation of duties unless they were duties that were supposed to be performed by the trustee and no one else, according to the trust document. And administrative functions easily delegable under current law, which takes us back to C. And in C we have self-dealing, right? Which means that the transaction is voidable per se in Florida. What do we mean by voidable per se? It's at the option of the beneficiaries. They can avoid the transaction when you have self-dealing, which you do when you buy or sell to or from the trust. And the beneficiaries don't have to give a reason. They don't like it, they don't like it. Okay, I don't want you guys to get big heads, but you did very well. And I use these questions, pretty much for every administration of the exam. You guys did a lot better than most groups, so I congratulate you on that. Yay, but, I'm sorry?
For us who are not, when you pick me up, so that's horrible.
Yeah. Now, we're going to, what I'm going to ask you to do now, because we do have that trust question, and I do want to get you out of here by 5:30. So I'm going to ask you to take a few minutes to read it. I'm going to run Rosario's ticket upstairs so it doesn't get lost, so that we know for sure that she won the hotel room. And yay Rosario. And there is a pro-rep component. You can play with it if you get there before I get back. We're not actually going to cover it because, again, I want to get you out by 5:30. So go ahead, take a few moments. I will be right back. How are we doing? We want more time, or are you ready to? A little bit more time? Okay, let's go ahead and see what we have here. And as I mentioned before, this question kind of writes itself. It is in the newer style. They give you very pointed call of the question. You know what you're supposed to be talking about, at least if you can find the right issues. And they're not that hard to find, quite frankly, in this question. So let's briefly walk through the facts and see what we can identify. So we have Susan, who transfers $400,000 to Ted and Tammy as trustees. Well, I guess they're telling you it's a trust question, right? You know, Susan S. settlor, Ted and Tammy trustees. So can you use S and T? Sure. With a written irrevocable trust agreement. Now, the date is 1992. At that time, trusts were presumed to be irrevocable in Florida, but today we know the presumption has been reversed. So be on the lookout for the question of whether it's revocable or irrevocable. If they don't tell you, today we presume revocable. The agreement provided that the income was payable to Ted for 10 years. So right now we see that we've got Ted as trustee and Ted as beneficiary. Now, I've seen, and I don't know if it came from some of your commercial courses or quite where it came from. I've seen a number of people state the elements of a trust, and they include as a separate element that you can't be the sole trustee and the sole beneficiary. That's not a separate element of the trust. It's a rule that you may need and you want to talk about here, but you talk about it in the context of Ted as the trustee or Ted as the beneficiary. It's not a separate element. But is he the sole trustee and sole beneficiary? No. Number one, we've got Tammy, who falls out of the picture fairly quickly. But we also, and here's another error that people make all the time. The trust is set up to pay the income to trustee for life and then remainder to various beneficiaries. Now, one trustee who is getting all of the income during the lifetime of the trustee. We still have a split between legal and equitable ownership. As long as you've got a future interest out there, can even be a contingent future interest out there, there's a split between legal and equitable. Remember that because that's something that's tested a lot. Okay, so Ted gets the income for 10 years. He's got an equitable lease. Or an equitable term of years, excuse me. And then after 10 years, the trust is to terminate with trust assets to be distributed as follows. And actually, they're telling you then that the interest of all of these remainder persons is equitable. If your trustee has a duty to distribute the proceeds at the termination of the trust, then the interest of the remainder persons is equitable rather than legal. 1/4 share to Tammy, but only if she survives Ted. So we have, obviously, a condition precedent. her remainder is contingent. Well, it's going to be contingent anyway because of the way the new trust code operates in terms of anti-lapse. A 1/4 share to Bob. Now, I want to give you a little rule, and it works like a charm. If you're really stuck and you don't know what else to do, if you have a trust question and somebody's named Bob, just give everything to Bob. He always ends up with pretty much everything. What I'm saying is, if they've got a character named Bob, Bob always ends up with everything. I don't know why, but it's really true. So that's why I said, if you're stuck, if you know the rules. No, it's not a Beth or a Bill or a Bruce or any. No, it's always Bob. Okay. So 1/4 share to Bob, and he's going to end up with a lot here. A 1/4 share to be distributed for religious purposes. Now, we have a change in the rule, in the law, in respect to that gift. Again, it's an older question, but I like it because the issues, while the law has changed a little bit, the issues are still there. So we'll talk about the change in the law in respect to the gift for religious purposes, and 1/4 share to be distributed equally among my friends. Again, another change in the law that you want to be aware of. Now, Susan dies in 1995, so our settlor is now dead. If the trust had been revocable, which it wasn't, but if it had been revocable, of course it becomes irrevocable on the death of the settlor. She leaves her entire estate to Bob. What did I tell you? You guys are laughing. Bob is supposed to get everything. He gets everything that doesn't go through or pass through the trust. Tammy dies in 1997, which means that she didn't survive Ted. And so her gift will fill in the blank. What word? Lapse, right? So we're going to talk about the trust anti-lapse statute. After Tammy's death, Ted maintains a policy of investing the trust assets in 90% corporate bonds and 10% stocks. Why does he do that? Because bonds spin off income, and stocks, hopefully, not recently, but hopefully will grow the principal. He's the income beneficiary. He wants everything in bonds, so he gets more income. He has failed to diversify. Absolutely. And that's something, by the way, they love to test, diversification of assets. He has to diversify, unless, of course, the trust document tells him otherwise. Under the new trust code, also, if he believes that non-diversification is in the best interest of the trust, he can petition the court. That's also a change in the law. Bob comes to you for advice. He wants everything. Can Bob have the trust declared invalid? So we're going to start there. And then, can Bob have Ted removed as trustee? If the trust is not declared valid, how will the trust assets be distributed on termination? And then, of course, the validity of the fee arrangement, which we're not going to talk about just because we don't have enough time. So let's look at that trust. Let's look at the validity of the trust. Elements. You need a settlor. You need a trustee. You need trust race, ascertainable beneficiaries. You need a trust purpose, a valid trust purpose. But honestly, unless it's a trust set up to kill somebody or something like that, pretty much any trust purpose is going to be valid. So take a sentence, mention it, but don't spend a lot of time on it. The resulting trust, of course, is not a true trust, but it's what happens whenever a gift fails. So we want to mention it. Let's look at our elements. And I would recommend that you go, if you get a trust, especially if they ask you if the trust is valid, but even if they don't, take a moment to walk through the elements one at a time. Settlor, you need a competent settlor, but they don't give you anything to work with here. I wouldn't spend a lot of time saying, well, what if Susan had been insane or whatever? No, just, Susan's our settlor. She appears to be competent. I know, once again, I know you learned a lot of rules, but don't change the facts just so you can talk about stuff that you learned about. As the graders, they won't know your new set of facts that you're spinning. Their grading outline is already set, and it doesn't take that into account. Trustee, we need that split between legal and equitable ownership, which I think you're all aware of. And of course, don't worry about statutory sites. They're just in there in case anybody actually wants to look the statutes up. You do not need to know sections of the trust code unless it helps you remember the rules, but I wouldn't worry about it. But we've got that split, Ted and Tammy. Now, here's our rule. Ted does end up being the sole trustee because Tammy dies. But do we still have the split between legal and equitable? Yes. And does the court need to name a new trustee? No. Now, the trust could say that you must have 2 trustees, in which case then the court needs to step in and name a new trustee. But otherwise, which is the case here, as long as you have a trustee, the trust will continue.
How is his interest still split? How come
His interest is still split because you have those remainder interests that follow his term of years, right? And they like to test this particular point. So remember that if you've got someone who ends up being the sole trustee, which Ted is at this point, who is currently the only person enjoying a beneficial interest, and when I say enjoying, actually getting the income, the split between legal and equitable is still maintained as long as you have some future interests out there, some people who will or may, because they can be contingent interests. As long as there's somebody out there in the future, even if it's relatively remote, that's enough to maintain the split between legal and equitable ownership. Okay, and you know, people always remember trust won't fail for want of a trustee. That's a rule, you know, everybody learns that rule. Don't throw it in unless you need it. But it is true. If for some reason Ted is removed here because he has breached some fiduciary duties, then the court will step in and name a new trustee. Okay, so let's take a look now. We already talked about that. Oops, trust race. Not much I would say about trust race here. Sometimes there are more issues dealing with trust race. Anything, of course, can be a trust race as long as it's in existence or growing out of an existing contract. So cash, which is what we have here, real property, personal property, whether tangible or intangible. And once again, you can have, for example, royalties, future royalties, as long as they are growing out of an existing contract. But if it's a promise of something you might get in the future, an expectancy under a will, for example, that cannot form the basis of a trust. Now, beneficiaries. They definitely wanted you to talk about beneficiaries here. If it's a private trust, this is a mixed trust, by the way, because it's got private and charitable beneficiaries. But for the private portion of the trust, you must have ascertainable beneficiaries. For the charitable portion, of course, you cannot have ascertainable beneficiaries. You can name a charity, but you can't name individuals in the charity. So we start with people who are named in Susan's trust, Ted and Bob. They're named. They're ascertainable. We're done. They're beneficiaries. What about Tammy? Well, she's an ascertainable beneficiary, at least at the start. She's alive. She's named. We know who she is. There's a condition precedent. But she's still an ascertainable beneficiary. Now, whoops, sorry, I went too fast. The trust for religious purposes. Again, a change in Florida law. It sounds kind of vague, but you'd be surprised at how often that particular phrase comes up. Under current law, again, a change from the past law, the court has the power to pick an appropriate charity. It is not the exercise of the cypre power, however. Don't mix the two up. Cypre power is used by the court when the charity that is named is no longer in existence or the charitable purpose cannot be served. For example, a gift to a charity, case from Florida, there's a gift to a hospital to build a whole new hospital building and name it after the donor's wife. There wasn't enough money to build a whole new building. The purpose failed. That's when the cypre power comes in. Here, it's just a general gift to charity. And so the court now by statute has the power to pick a charity. trustee used to have that power. So court can pick a charity, pick it out of the hat, whatever seems to fill the settlor's charitable purpose. Now, my friends, at the time this question was written, that gift would have been void. The beneficiaries weren't ascertainable. Let's talk about that a little bit, and then we'll talk about the new Florida rule. You can make a gift to a class, my children, my brothers and sisters, my nieces and nephews. So you don't have to name the individuals, as long as you can figure out the scope of the class. But when you have a gift to my friends, you have to hope we all have a lot of friends. Kind of tough to identify. Today, in the internet age, you got your Facebook friends, you can figure out who they are, but they're probably not your friends anyway. Maybe. So, my friends is suspect. And again, under the rules as they were written then, that gift would have failed. Mind you, you can use extrinsic evidence to prove the class. And there's a question that I sometimes use that's probably in your material someplace, in which there was a gift, a portion of a trust made to the jocks I met at my 20th high school reunion. Okay, well, that's kind of vague, but you could figure out using extrinsic evidence. Who signed the guest book? Who paid to go to the reunion? Look at the class photos from the reunion. This one, however, too vague. But by a relatively new statute in Florida, the trustee is given what amounts to a power of appointment in this situation. If the trustee picks 1, 2, 3, how many ever people from that vague group of friends and makes the appointment within a reasonable time, the court will uphold the gift. If that appointment isn't made within a reasonable time, whatever that might be, then that portion of the gift fails. Important distinction, it's something they tested a lot, so keep it in mind again. Our trustee, Ted, now has the power to name a couple of friends, or a few friends. Now, if that gift fails because Ted doesn't appoint friends, that's when you get that resulting trust, which is what was envisioned when the question was written. And just that portion, that 1/4 to my friends, would fail. Falls back into Susan's estate through that resulting trust. The resulting trust always goes back into the settlor or the settlor's estate, and then would pass through Susan's will to guess who? Bob the Bandit. I'm telling you, they set this question up so Bob gets everything. Now, that's the resulting trust part. So, we've found under current law that all 4 parts at least start out as valid gifts. So we have 4 valid sections, if you will, of beneficiaries. 1, charitable. So it's a mixed trust again, mixed charitable and private, the other 3 private. That's all we do at this point because guess what? We have established a valid trust. Notice, by the way, that I didn't spend a lot of time talking about the writing requirement. Why? It's number 1, it's satisfied. Number 2, this is an irrevocable trust of personal property. As long as you prove it by clear and convincing evidence, you wouldn't even need a writing because it's irrevocable.
If it's testamentary, then you would.
Oh, if it's testamentary, absolutely. There's a difference. First of all, if it's in a will, of course it's going to be in writing that satisfies will formalities. Be aware, though, in Florida, under current law, any testamentary aspect of a revocable trust has to be in a writing that satisfies full will formalities. So once again, just to be safe, any testamentary aspect of a revocable trust, revocable inter vivos obviously, revocable inter vivos trust must be in a writing that satisfies will formalities. What is a testamentary aspect? Testamentary aspect is any part of the trust designed to pass assets on or after the death of the settlor, which means pretty much any revocable trust these days. So if you see a revocable trust on the exam, which they're likely to test at this point, then make sure you have a writing, not just a writing, but a writing with full will formalities, the testator who signs in the presence of the witnesses, who signs at the end in the presence of the witnesses, who sign in the presence of the testator and each other, right? So look for all the will formalities. Now, what about removing Ted as trustee? We want to know who has standing to remove Ted, and what are the grounds, and then, of course, the replacement trustee again. So, Florida courts, of course, it's the circuit court. I've mentioned before, and we'll talk about it a little bit when we get to the Florida con law question, they like to throw in little bits and pieces of jurisdiction and standing threshold questions in other subjects. So always be on the lookout. A sentence to tell them that you're in the circuit court gets you a couple of points, right? Anybody, any trustee, any beneficiary, trustee or the settlor, if the settlor is still alive, can seek removal of the trustee if the trustee has breached fiduciary duties. There is a special category of beneficiaries called qualified beneficiaries, but that's not relevant here. Use that term qualified beneficiary only where it's relevant, which for your purposes is likely to show up only in the context of termination of an irrevocable trust. And that's not the issue here. So we're just talking about removal of a trustee. Any beneficiary, not just a qualified beneficiary, can seek removal of the trustee if the trustee has, again, breached the fiduciary responsibilities, which we're going to see, of course, occurred in this case. So, what are the grounds for removal? Remember I said they love to test trustee duties. If you didn't get very far into trustee duties in your wills and trust class, make sure you review these rules. Any serious breach of those duties, and there are lots of duties. In this case, we start with the prudent investor rule, because the trustee has to invest as would a prudent investor. Specifically, diversification, which they do love to test. And as I said before, the trustee is supposed to diversify unless the trust document says otherwise, or under current law, unless the trustee believes it's in the best interest of the trust, not the trustee, but the trust, and the court approves. Here, Ted's attempting to avoid diversification for his own personal benefit. Not going to fly. So he's violated the prudent investor rule. We also have a duty of impartiality. Trustee has a duty to treat all beneficiaries equally, which can be a bit of a juggling game. But that means in making investments, the trustee has to look out for both income and principal. And what did our trustee do in this case? He looked out for the income beneficiary, that's him, at the expense of the people who would take the principal when the trust is distributed. That's the friends if they're appointed, and that's Bob, who's obviously the one who's bringing this suit. So make sure if you see a failure to diversify that you think about impartiality as well, because they're likely to go hand in hand. Both are breached in this case. What we don't have in this case, another frequent flyer, that's why I gave you that one multiple choice question, obviously we don't have self-dealing. And they like to test that too. Just be aware again that it's an easy thing to test. So if Ted has indeed breached his fiduciary duties, which clearly he has, he can be removed. And what do? There's that rule that everybody loves to cite. At this point in time, the court will name a replacement trustee with only one exception. if the trust document states that Ted and nobody else, which clearly wasn't the case here, but had it said Ted and no one else can serve as trustee, then the trust would fail. But they're highly unlikely to give you that fact situation. So you get a replacement trustee in, and the trust continues. So now the question becomes, how do we distribute the assets? Following the order of the call of the question. So we start first with the income to Ted for 10 years. He gets to keep the income. The trust gives it to him, and he gets to keep it despite the fact that he breached his fiduciary duties. Because we put his role as trustee on one side and his role as beneficiary on the other, and we don't cross the line. So he can be removed as trustee, and he might have to pay some damages if he caused damage to the trust. But it does not mean he doesn't get to enjoy his beneficial interest. He gets that income for 10 years anyway. But at the end of the 10 years, we had a 1/4 share to Tammy. She failed to survive Ted. So her gift is going to fail. It's going to lapse. Now, is Tammy protected by the trust anti-lapse statute? The answer is no. Easy answer as to why she's not protected. Because, well, she's dead. But which means her gift lapses unless it's protected by the anti-lapse statute, right? Thank you. We have an express condition of survivorship, which means that the settlor took the gift outside the scope of the trust anti-lapse statute. Any express condition of survivorship takes the gift outside the scope of either the wills or the trust anti-lapse statute. So the easy answer is it doesn't apply here. But let's consider for a second if it didn't have an express survivorship requirement, just so we understand how it would work. The trust anti-lapse statute does not have a relationship requirement. So the fact that Tammy is not a descendant of Susan's grandparents isn't going to prevent the trust anti-lapse statute from applying in this case.
Does it go to her heirs or like her husband?
No, good question. Here's where the trust anti-lapse statute is like the wills anti-lapse statute. Remember with the wills anti-lapse statute, two things. You need the relationship requirement, and you need someone who died with lineal descendants. The trust anti-lapse statute does away with the relationship requirement, but it maintains the requirement that the person who has predeceased leaves lineal descendants. So, and they didn't give you any in this case. So if Tammy didn't leave lineal descendants, her gift, once again, would not be protected by the trust anti-lapse statute. It would not go to her husband if she had one. Must be lineal descendants. Wouldn't go to brothers and sisters. Has to be lineal descendants. And well, remember again, though, of course, the express language here does take the case outside the scope of the trust anti-lapse statute. One final thing I want to mention. It's a really small thing, but, it can get you some extra points. Remember the gift to Bob, just an outright remainder interest to Bob, sure looks like a vested remainder, right? Because he's ascertained, no conditions precedent. The trust anti-lapse statute takes all future interests and turns them into contingent remainders, contingent on surviving to the distribution date. So even Bob's apparent vested remainder is actually a contingent remainder for the purposes of the trust anti-lapse statute. He would have to survive to the distribution date, even though the document doesn't actually say that. It says to Bob, if he survives Ted in this case, because that's the distribution, or the 10 years of Ted's, because it's actually measured for 10 years. To Bob if he survives for 10 years, but if he does not, then to his lineal descendants. Trust anti-lapse statute just rewrites the gift. You don't have to go too far down that path, but just remember that it does take those vested remainders and turn them into contingent remainders. So, remember again, when the gift to Tammy fails, resulting trust arises in favor of Susan, or at this point, her estate. She devised everything to Bob. Bob gets that quarter. Question?
So if the settler has a present interest, could he, and he, I guess, retains a reversion, and would then he merge out all the contingent remainders?
Good question. Probably it would more likely be in this case if we gave Ted a present interest followed by those remainders and then followed, well, you wouldn't give it to Ted after that. It would really, maybe it would be the settlor. Because, what, if you have a life estate followed by contingent remainders in property law, the contingent remainders, if they're the last interest, they do have to be followed by a reversion in the settlor. But they'd be created in the same document, and so merger wouldn't occur. Remember that, and that's way outside the scope of what we need today, but it's actually a good question. And the answer is, if you have the, what I call it a sandwich. You got the two pieces of bread, the present interest and the reversion, and you have a contingent remainder in the middle. The two pieces of the sandwich, the bread, will squeeze out the contingent remainder, but not if they're all created in the same document. Good question, though. Okay, the 1/4 interest to Bob. Bob, it is a contingent remainder, as I just said, but he survived. He gets his 1/4. So notice he now has a half. The question as originally written gave 3/4 of the remainder in the trust to Bob, because that gift to the friends also failed. So that's why I say Bob is always going to get pretty much everything. 1/4 shared to religious purposes. Now the court gets to choose. Used to be the trustee could choose. The court chooses now. And finally, my friends, once again, now Ted, as the trustee, or the replacement trustee if we've removed Ted, has the power to make an appointment within a reasonable time. That's a question of fact, whatever reasonable would be under the circumstances. And if he does, then the friends that he appoints get to take. If he doesn't, once again, resulting trust, which means that quarter falls back into Susan's estate and passes through her will to Bob the Bandit. So I just kind of wrapped it up, and that's our conclusion. Any questions? There's a lot of stuff in this question. Yes, Jaquetta.
What do we call, I guess like the 1/4 share to Tammy? They're not provisions. What do they call?
The question is, what do we call the gifts in the trust? The technical term is beneficial interest, but you could call it a gift. That would work too. But technically, beneficial interest. Okay, that's about it for today. Now, remember again, we're back at it in 2 weeks for business entities. In the interim, please feel free to send me essays. And also, some of you have been asking about specific multiple choice questions. I got a question on one of the breaks, and please feel free. I may agree with the question, I may not. This one, I wasn't real pleased with the question for the same reason that you weren't pleased with it. But do ask. Don't, kind of sit there and say, what do I do? If I don't know the answer, I will certainly find somebody who does. Okay? Have as good a weekend as you can.